say welcome to today's webinar, which I'm hosting on the topic of divorce and financial planning. My name is Graham Fraser, and I'm a partner and head of family at North London law firm OGR Stock Denton. I'm joined today by guest speakers Helen Howcroft, Chartered Financial Planner at Equanimity, and Claire Heppenstall, Family Law Barrister at 1GC Family Law. So I'm just joining the slideshow. The format of today's webinar will run as follows. We will each firstly explain what we do, and then Helen and Claire will explain in more depth their roles in the process. We will then provide a practical analysis of the issues that tend to crop up in our work using 2 case studies. On your screen, you will see a chat and Q&A section. Please do feel free to enter your comments in the chat section, and we will try to pick these up throughout the webinar at appropriate times. I'm just waiting for the slides to work. One moment. Doesn't seem to be. Here we go. Right, so now for a little more about me. My expertise is in advising on financial settlements on divorce, involving complex assets and substantial wealth, and on cohabitation, for which I hold the Resolution Specialist Accreditation. I'm also specialist accredited by the Law Society. I'm known throughout the family law community for my interest in the rights of unmarried couples, and am the chair of Resolution's Cohabitation Committee. In recognition of my published work, often in respect of the plight of unmarried couples under the current law, I received the Family Law Commentator of the Year award in 2018. Helen and Claire will next explain more about themselves. So I'm just going to pass on now to Helen.
Thanks, Graham. Hi, everyone. I'm Helen Howcroft. I'm a chartered financial planner specialising in complex pensions and divorce. I established Equanimity back in 2004, and we're a central London firm based off financial advisors, providing financial planning and cash flow modelling services to clients. I have an extensive experience advising clients going through divorce, ranging from areas such as financial coaching, analysing pensions, analysing family assets, cash flow modelling divorce settlements, as well as writing mortgage capacity reports. I either work directly with the solicitors, with clients referred by their solicitors, or with mediators, where I attend mediations with a couple and I'm acting there as a financial neutral.
And next I'm going to pass to Claire.
Hi, Claire Heppenstall. I practice from 1GC Family Law. I've been practicing exclusively in family law since the early 1990s. My work encompasses both private children work, but also financial work, both for married and unmarried couples. And in terms of the financial work, it covers the whole range from high capital net worth individuals to cases where there are more income assets available, and cases in between. So it's the whole range of financial remedy work that I get involved in. And I'm involved from the outset pre-proceedings, often advising on sort of strategic approach, and then throughout the court-based process involving the first appointment, financial dispute resolution appointment, and final hearings, and advising and trying to assist clients to get settlement, because often that's likely to be the best outcome for both parties. And if that's not possible, then achieving the best settlement outcome by virtue of the court contested process for the client that I'm instructed to act on behalf of. Thank you.
Thank you, Claire. And I'm going to pass to Helen now, who's going to explain a little bit about her work and the roles that she takes on.
Great, thank you, Graham. For the next 2 slides, we're going to be looking at very much the difference between what I do as the role of a financial advisor when dealing with divorce settlements to the input that a pensions actuary has within this area, because a lot of people get the 2 areas confused, and our roles are very, very different. Ultimately, as a financial advisor, my role is to translate the numbers being discussed as part of the divorce settlement to empower the client to understand what the numbers mean and to empower them to ensure that the settlement being proposed, they understand the implications of what those numbers mean to them down the line for things like how much of a property value can they buy and how much money can they spend. When we are, as financial advisors generally, because I know there's a lot of financial advisors on the call today, we know that financial advice is complex enough in the first place. But once we then add in divorce, when we're providing advice to clients going through the divorce process, clients that I generally work with are quite overwhelmed because they find the whole process overwhelming. They're incredibly vulnerable as clients, and that's where it's very much really translating what they want to achieve and understanding what they need to achieve is really important. So some of the key things we do when we're working with clients directly is something like modelling the settlement that's being proposed on a cash flow modelling system, because I generally find that using cash flow modelling with clients going through divorce takes the numbers and the jargon such as pensions and tax planning and GIAs and ISA out of the equation and can really translate things into a very straightforward graphical format on the system we certainly use. If the screen is showing blue, it means that the client has enough money to be able to achieve what they want to achieve with the settlement being proposed. But actually, if there's red, it means that the client is likely to run out of money. So it's really important that they understand. Graham, could we go back a second? Thank you. That the client understands what these numbers really mean to them. The clients that we work with generally don't understand how much they're spending on a monthly basis. That especially, and I'm going to be very generalist in some things that that I'll be saying, but things like where you have a wife who could potentially be having that stay-at-home housewife kind of role, I generally find that they do not have the same grasp and understanding of family finances as what potentially the husband does in that case. So it's really helping that client understand what these numbers mean to them. They don't need to understand the technical aspects of it. When we're working with the family lawyers though, the kind of work that we do is very different, because when we're working with family lawyers, there's normally a very specific piece of work that needs to be done. Things like if there are several pensions in question that are being looked at being shared, our role very much is looking, are there any of those pensions that should be retained by the original party, because are there any features within those pensions that would be lost if they were transferred as part of the settlement. Equally, things like identifying that if there is a final salary scheme, to not just take the cash equivalent value being given at face value, that final salary scheme could be worth substantially more than what they are. As a financial advisor, we ultimately have a far deeper understanding of how these complex pensions work, and we're very much there to provide that expert advice to empower the solicitor to formulate those right settlements for the clients. One of the frustration things I often have when I'm dealing with clients is, especially where they have gone and agreed to settlement themselves without using any financial experts, we often find the financial settlements aren't actually workable, because either that they've already sold the family house and there could be maintenance being put in place, but the maintenance hasn't started yet, and now the person relying on the maintenance is finding that actually they cannot get a mortgage at the moment. Equally, that where there isn't enough liquidity, or that the settlement may leave that one person simply doesn't have enough money to rehouse themselves and to buy another property, because they've only considered the deposit for the mortgage that needs to be purchased on that property, and not thought through the consequences of the stamp duty and all the other costs associated with purchasing a property. So our work very much is, we're here to provide technical financial planning advice. We provide financial advice either on a single, most of the work we do is we're working with the solicitor, we're representing one client, but equally we will happily work as a financial neutral and to provide joint experts reports there as well. If we go on to the next screen, if that's okay, please, Graham. Then if we then look at where the pensions actuary fits into this, pensions are normally the second biggest asset that a divorcing couple have when they're going through a divorce. And just because a transfer value, as they're known, or a value is given to a pension, it doesn't necessarily mean that that value given on that pension that people write on the Form E actually represents the real worth of the pension. And a classic example of this is a final salary scheme, also called defined benefit schemes or career average revalued earnings schemes. All of these types of pensions are promises in the future to provide the client with a guaranteed income. Now, what a pensions actuary will do is look at, if we needed that income to be replicated within a personal pension type environment, does that transfer value given for that final salary scheme, would it secure the same level of income to the other party? And so what they do is really look at the value of those pensions to see, are those pensions worth more than what there's been there in the first place? And what they're often then instructed to do is to provide a split of how the pension should be shared, to provide typically an equality of income or equality of lump sum. Those are the two main things that people look at. What I find quite often is that the pensions actuary are given all of the information they need, that the state pension is often overlooked. Now, the state pension these days is worth just over £9,000 per annum, and there has been changes made to the state pension in recent years that means that where potentially one party has been a stay-at-home housewife or stay-at-home mum, and especially where they haven't claimed child benefit, they may find that they have a very, very, very poor state pension entitlement. So it's really important not to forget what that state pension, to be making sure that we're looking at the state pension income as well as part of the work that the pensions actuary is doing, because it will impact the overall level of income that the pensions that those clients will have in retirement. Now, pensions actuaries will also take into account things like offsetting, especially if the family law is already talking about how the assets are likely to be split. There is a big difference between £100,000 equity in a family home and £100,000 value of a pension, because ultimately with the pension you might not be able to cash it straight away, and also there are tax consequences if you're going to cash that in all in one go, and the pensions actuary will take this into account when arriving at their numbers if that is required. But it's really important that when a pensions actuary is instructed to prepare a report, that the instructions are very clear in the first place of what you are actually wanting, what you are looking to achieve, or the family lawyer is looking to achieve by getting the report to be done. Now, pensions actuaries, I will just touch on timescales as well on pensions actuaries. Pensions actuaries are very, very busy people. And typically what we see is that pensions actuary reports typically take around 6 months to be turned around, with the delays. If you've got final salary schemes, there can be delays of up to 12 weeks in simply obtaining the information in the first place to enable the actuary to do the work. So it's really important when instructions being made to the pensions actuary, that we know what we're actually asking them and why we're asking them to do that piece of work in the first place. Claire, Graham, I don't know if you want to add anything in at this point with what you've seen with the actuarial report.
Pension reports can take a very long time to come. It's absolutely right. We've had instances, certainly over the last few years, of having to adjourn hearings, that actually court directions are made with the prospect of adjournments if pension reports haven't been received. I think the other thing that's definitely come across in recent times is that people are more sceptical, I think, about pension offsetting, and that in orders that are made by courts, in terms of imposed orders, they're more likely to be pension sharing. So there's definitely a move towards that. Claire,
I'd agree with that. And I think also because there is no universally accepted approach to how you equate offset of a pension versus liquid capital assets. There are different approaches that can be argued for, which is why often people prefer to deal with them separately. So share the pension and then look at the liquid capital separately. And I think one other aspect of the pension actuarial report that is really important is particularly in relation to final salary schemes, because the final salary scheme administrator will give it a value which you couldn't buy the same scheme on the market. So if you say a person in a blue chip company has 100,000 a year salary, pension payment from the age of 60, you wouldn't, and his fund is said to be, say, I don't know, million. A pension actually looking at that would say, if I was to buy my client 100,000 a year from the age of 60, it's going to cost me something north of 2 million. So that's why it's important to have a proper valuation put on final salary schemes particularly. And so this is where pensions advice is absolutely key. And I have to say that most family lawyers would be negligent not to get a report, actually, because we're not experts. We rely on financial advisors and pension actuaries to give us the advice, because although we may have an overview, we are not there on the detail. It's obviously a specialist area, and that's why you need that expert report. So although people think, well, why do I need to spend that money? It's money well spent, even if it does take more time than you'd want. Rather base a settlement or an outcome on the correct figures, because that's going to be a fair outcome, which is ultimately what the court is trying to achieve.
Yeah, absolutely right. And it actually, Claire, it appears on our indemnity insurance questionnaire whether we've advised on pension sharing on, I think, pensions over £500,000 in every pension. And I've been to professional conferences where there are people who make a living out of these negligence claims, I have to say, which is a bit of a sorry sight. I'm now next going to go to the next slide, which is one for Claire.
Right. I just want to talk a little bit about how strategic financial advice can be dovetail and work really well with ongoing legal advice throughout the process. And that's right from the start, because I think that experience shows that if you adopt a strategic approach at the outset, not only is it helpful, but it's going to be potentially cost saving, which is obviously always something to bear in mind. So it's important to think about the likely shape of the case, and experienced family lawyers will obviously be aware that the discretionary exercise that the court has to apply using Section 25 of the Matrimonial Causes Act, which encompasses a range of factors in terms of the person's resources and income, etc., capital availability, pensions, etc. All those factors are going to be in play. And so it's important to think from a strategic approach at the outset. And it may be that even touching base with a financial advisor as a solicitor may be very sensible at the outset. And I know that Helen and certainly Graham are members of the collaborative pod model, and they regularly use colleagues in different sectors to chat things through. And I think that that's a really helpful way. And actually it's really beneficial to the client, because it may throw up factors that they wouldn't necessarily have considered on their own. So absolutely, there's I think, a real use to having an interface from the outset, even before proceedings. Once you're in proceedings, obviously, the first thing that financial lawyers will have to do in a case where parties are married is preparation of the Form E, which is obviously the financial sworn statement of assets and liabilities that each party has to present. And it's quite a complex document in terms of the financial information that needs to be gathered. And I think that, again, it doesn't necessarily happen in many cases, but I think that actually using a financial advisor at this stage can be really helpful. And we'll come on to that in the case study that we'll discuss later. Because in terms of periodical payments that you might be looking for at the end of the case, that will factor into the income needs that you're setting out in your Form E. So again, the interface with a financial advisor may provide a really useful guide to filling out that form as appropriately as possible. When you get to the first appointment, this is the appointment where the court looks at what the issues in the case are going to be and marshals what evidence is going to be required in order for the court to assist the parties to get settlement, what information is needed. Where there is pensions involved, it's likely that there would be a mortgage capacity report. I know anecdotally I was saying that recently she had experience of talking to family lawyers and they didn't do that, which I found faintly shocking, because normally it is going to be a specialist area which you're going to need advice on. And the first point is that it's normally a jointly instructed pension report. And as Helen has indicated, the letter of instruction is going to be really important because you need to be looking at what type of pension schemes there are. And of course, by the time you come to your first appointment, you'll have seen the Form Es and you'll have seen the disclosure about the pension funds that are available and whether there are capital purchase schemes or final salary schemes. And you will be, there may be a mixture of schemes for someone who's had a lengthy working life, they may have dotted about. And so it's going to be important in terms of getting advice to think, is it income equality we're looking at in retirement, and at what age? At 55, when you can first draw down a pension, 60 or 65? So all these factors are important. How the pensions should be shared? Should it be a mixture? Should everyone have a share of final salary, or should there be a sharing of capital purchase schemes? All this sort of information is going to be very important to be addressed in a pension report. And as Helen's already indicated, the letter of instruction is going to be important. So again, family lawyers need to think, I think, more proactively about getting an IFA's assistance in that respect. Mortgage capacity reports. Now, these tend to be directed on each party obtain advice about what they can borrow by way of mortgage and likely cost. My own view is that it should be a joint instruction of one mortgage advisor, because otherwise you get a problem where you'll have two, for the wife, they'll have taken one particular approach, not clear what income they've taken into account. Whereas if you've got one mortgage advisor advising in relation to both clients, at least then you will know that they've approached it on the same basis, which is going to be helpful. But again, the letter of instruction is really important. And recently I had a case where the parties had a large property portfolio which generated income. Some properties were in the husband's name solely, but they shared the income for their tax return purposes, albeit that he had more by way of income. And the mortgage report wasn't actually very helpful because it used the current tax returns to base a projection of likely borrowing ability, which is obviously the way the mortgage companies will approach it. But actually, because of the way the division of the capital in the property portfolio was going to shake down in the final analysis of what was the settlement going to be on a fair outcome basis, actually it bear no relation to the income they were likely to have. So it invalidated actually that report and didn't make it in any way useful. So think about the letter of instruction. Again, when you've got all your information available and when you've received your actuarial pensions report, at that stage, I think the risk is for family lawyers just to accept what the pension actuary says, because they're the expert, you don't know any better. Now, at that stage, you might really want to speak to your own independent IFA to ask them to look at the pension report and see whether they accept all the assumptions, or whether you should be asking questions of the expert, obviously because your client will have their own perspective that they want to put forward. And so at that stage, I think it's really helpful to have some additional independent financial advice from an IFA to guide you, and not just accept what the pension actuary is saying. It may be that it's appropriate, but at least then by having someone with a bit more nous looking at it, they will be able to really ensure that you're meeting your client's needs from every perspective. Similarly, when you, again, are clear on the way forward, an IFA can help you when you're pitching your without prejudice proposals, which you have to do in the financial remedy process, because obviously the court's trying to encourage people to reach settlement because it saves on stress, it saves on costs. A good without prejudice offer is reasoned, and so it will be helpful to have an input potentially from an IFA. You could exhibit cash modelling forecast to demonstrate that the husband's offer in relation to maintenance for the wife, for instance, will ensure that over a certain term she's going to have enough money to meet her needs, or in terms of an analysis that her case is overstated, you might produce some analysis of the information produced in Form E. You're really using it to shore up your arguments that you want to sell both to the other side, but more importantly to the judge at the Fdr appointment, which is the next stage. And there's the financial dispute resolution appointment. I'm sorry, it's the FDR, we call it for short. This is the hearing at which the court really tries to assist parties to reach settlement and bring them closer together. And so if you've got reasoned arguments that you can evidence based on some input from the financial advisor, actually you're more likely to be able to persuade a court that your position is reasonable and fair. And that's what the court is ultimately trying to assist the parties to achieve, a fair outcome. But of course, if you aren't able to reach settlement, technically you're going to have to consider whether if you want to rely on that sort of evidence at trial, because a financial dispute resolution appointment is without prejudice. If you want to rely on those sorts of arguments, in effect, you're using your IFA as an expert to persuade the court of the strength of your arguments, then you're going to have to consider what we call a Part 25 application, which is under the family proceeding rules, permission from, you're going to have to obtain permission from the court to instruct an expert. And of course, the other side may object to it, or they may say, oh, actually, we want to have it. This is a good point, but we want to have a joint instruction on this because we want to try and steer it the way we think is more fair. And so again, these are issues that for trial, if you're not able to settle it, may be really helpful. And then in terms of trial preparation, again, financial advisors can really assist with the sort of analysis that you might want to put into your Section 25 statement, which is your statement, your factual statement, which sets out all your needs and resources and liabilities, so the court has a full picture of the issues that it needs to determine for the case. So again, that sort of analysis can be very useful and helpful. And I think that we as family lawyers don't necessarily use that independent resource as much as we should do. And I know that in cases where I've been involved where it has been used, it has added another dimension which has been invaluable for the clients. So I'm a great supporter of that as an approach. And I have to say, I don't think it necessarily needs to be an expensive additional cost, because actually you're going to save money potentially, but if you manage to settle the case as a result, or actually it's going to inform the outcome. So I think that it is often money well spent.
Okay, we're going to go shortly to the case study scenarios, but I just really want to say thank you to Claire, because she's really eloquently put that, and I don't know how many minutes she spent on that, but really that's exactly how I see it. And I have to say that over the course of my career, I'm not sure I always saw the flags. I definitely see the flags now, and really it's important to work with other professionals early on and at the right stages, because getting the information right at the early stages gives you more chance of developing whatever whatever the scenarios are, actually be able to structure the settlement correctly and getting the right information. And just as a word of caution to solicitors, we're not authorized to give financial advice. If we do that, technically it's a criminal offense. So there is a temptation, because a lot of clients think that the solicitor is the one port of call and we've got the answers to everything. We haven't, and it's important to work in tandem with other professionals, with counsel and with independent financial advisors, because only that way can we actually deliver the right results and give the balanced, correct view. So thank you for that. And as you can see, there are various stages where we need to go and perhaps get that support and help. Okay, so I'm next going to go on to the next slide. As you can see, it's just an introduction. And what we're going to do today is to work through a couple of case studies, which we've had a thought about in advance, because we see that these are actually very commonplace scenarios that we find in practice. So I'm going to go to the first one, and I'll read that out. It involves a large pension. It's Mr. and Mrs. Smith, who are in their early 60s with grown-up children. Mr. Smith is the main breadwinner and intends to carry on working. Mrs. Smith has been a housewife and did not return to work. Mr. Smith already has a pension in excess of the lifetime allowance, and he has already taken his tax-free cash. Both need advice regarding splitting the pension. And what I'm going to do is I'm going to go firstly to Claire, and I'm going to take up, this is a common scenario. I've got all this information, I've got my formula, I've got all the facts, and I'm going to come and see you in conference. Can you comment, please, on the issues that you feel might arise here?
Well, obviously, Graham, the first thing we'll be looking to see what type of pension scheme Mr. Smith has, and is it a final salary scheme, or is there a mixture of schemes? This is certainly a case where we'd want to have a pension actuarial report, and we'd want to be looking at whether there should be equalisation of capital versus equalisation of income. Clearly, if Mr. Smith is going to carry on working, whatever pension report, pension share will occur to reduce down his fund, it will mean that he will continue to build on that fund post separation, whereas Mrs. Smith, she doesn't work, she never has, she is going to be stuck with whatever she gets on the pension share. So pension share isn't everything. Obviously, we don't know at this point in terms of what other assets there are, because the pension scheme is the biggest thing. But you'd want, the courts are very much keen on sharing pensions that are accrued during the marriage and which are a marital asset. And there may be issues about whether she should actually get more, because actually Mr. Smith, you say he's in his early 60s, he's got 5 years, so where he's going to build up pension. Should there be an equal pension share to reflect that? So I would be looking at what questions do we want to ask the pension actuary. Should the pension share be from now, age 62? Should it be from 65? Should it be 67, depending on when their state retirement pension age kicks in? And in terms of Mrs. Smith, she's obviously going to be vulnerable. If it's a final salary scheme, say, that Mr. Smith has, she's going to, most final salary schemes won't allow the transferring person to stay in the scheme. They have to take the money out and buy their own pension. Now, obviously pension rules have changed. You can buy an annuity, as you always used to do, or you can do pension drawdown. Now, Mrs. Smith isn't going to be a financially astute person. Mr. Smith's always organised everything. So in terms of what's going to be a best outcome for her, you might want to factor that in and ask the pension actuary about the different outcomes for her in that respect. So those are the things that really jump out for me initially. And that's the sort of additional advice that I'd certainly be wanting to have from the financial advisor or pension actuary. Yeah.
So Helen, passing to you, I've now been to see Claire. What are you going to tell me, or what are you going to pick out from this?
Well, I was going to say that really much depends on who you're representing, as Claire's highlighted, whether you're representing the husband or the wife. If we take it from the wife's perspective to start off with, as Claire said, she's going to be vulnerable. She's not going to be coming from a position of strength with her knowledge regarding her finances, but also the word pension is probably going to scare her quite a lot as well. She's going to probably think that she needs to have the pension because a pension is how you fund retirement, but won't really understand what that really means. So as a role of the financial advisor, I think when dealing with the wife, there are two aspects. There would be, first of all, we would be working as a financial coach to very much work with the wife to build up a picture of what her finances will look like in retirement or from now on, so that she can see how much money she can spend or what kind of life she can live post separation of the finances. But secondly, there is a second piece of work, which is the piece of work that me and you would be doing together, Graham, which would be very much looking at the pension to see, is there a clever way of splitting the pensions which can benefit the parties. Now, something like that, because the pension is above the lifetime allowance, you're able to apply a pension share to the excess amounts, if required, to the excess benefits above the lifetime allowance. If that's the case, she's able to take tax-free cash from that pension when it comes across to her and is transferred into her name. Now that actually benefits both parties because it essentially gives a little bit extra of capital, because there's going to be an element of that pension which is going to be tax-free in her name, which, if you weren't being clever with the way that things were being done with that pension share, would be lost in the detail if you just did a straightforward pension share without having that knowledge. So for me, it would be really helping you understand the technical angles that we can really look at with the pension, and then making sure that when the pension annex is drafted, that it's drafted in a way that benefits the parties appropriately to really make use of the tax planning. When we then look at the husband, it's a totally different case. It's really looking at the husband and say what the impact of transfer, applying the pension share against the transfer, as Claire's rightly said, will reduce his overall pension benefits, but actually he's already taken his tax-free cash, so which we would expect has already used up the whole of his lifetime allowance. So for him, it's really looking at how he's going to be saving moving forward to help fund any more money going into a retirement pot, and looking at the various places that he could be doing that. Equally, because he will be left with a pension because he's already, in this instance, taken the tax-free cash to pay down the family home, making him realise that there won't be a second bite at the cherry, that there is no more tax-free cash from these pensions that he's going to be able to take there whatsoever. So for me, he doesn't need anywhere near as much advice unless there are lots of different pension pots. And if there are lots of different pension pots, or there is one final salary and one defined contribution scheme, it's looking at whether, if the transfer as well was made against one of the pension pots, whether it puts him in a worse position or he loses valuable benefits by applying a pension share. Certainly with old type pension schemes, with things like executive pensions, you could fund them to have more than 25% tax-free cash. With things like retirement annuity contracts, they could have what's called guaranteed annuity rates, which provide him with a far higher level of guaranteed income in retirement. These are the kind of things that would be really important for the financial advisor, and the actuary should be, if there's pension actuary report, they should be picked up in the pensions actuary report. But if there wasn't one being applied, really looking at that level of detail to make sure that, you know, that we're sense checking that we're not going to be losing anything just by applying a pension share in a certain way.
That's very, very helpful, Helen. And I think that just is so much information. And it's the missing link, I think, between getting that raw data and then translating that in assessment that works for our client. And I think the thing that perhaps is missing is what Mr. and Mrs. Smith have to say about it and what do they want, because that obviously feeds into all the advice that we give. So that's a sort of third dimension of all of this. But, you know, in terms of what Claire was saying earlier on about how that sort of advice would inform a settlement proposal, I think is incredibly helpful to be able to do that, because it's not just about what are the raw numbers they're going to get. It's how does it work for them in practice when this settlement has been achieved. And I think also with these scenarios, why it works very well in the sort of collaborative environment, why it's so helpful. Okay, so what I'm going to do now is I'm going to go on to the second case study. And I'll just put that up on the board, as it were. And this involves Mr. and Mrs. Jones. They're both in their early 40s. They've got 3 children in private schools, aged 5, 7 and 12. Mr. Jones has a salary of £200,000 and has received a bonus this year of £600,000. Mrs. Jones, in contrast, is a stay-at-home mum, hasn't worked since having their first child. They spend all of their household income. The house is worth £1 million with a net equity of £300,000, £200,000 in pensions and £200,000 in ISAs and in cash. Mrs. Jones has asked for assistance in completing her Form E, and in particular needs help completing her expenditure schedule or income needs budget. But this advice would be for both Mr. and Mrs. Jones. And I have to say, just before we move on, this scenario is incredibly common. I see it all the time. Where my practice is based, it's London and the South East, although we get national instructions. This happens a lot. So I think it's very, very helpful to hear about this. So Helen, can you explain the work that you would do assisting Mrs. Jones and your thoughts in general about this?
Yeah, well, can I just say these guys are having a great time and have had an absolutely great time, you know, with the amount of money that they're spending up until now. The reality check that this couple are going to have, they're going to have a massive coming down to earth when separating their finances, because it is very clear that the way they have been living their lives up until now, there's going to be some kind of change afoot. With the wife, there is so much work that you can do with the wife in this instance, because she will have no clue whatsoever as to where the money's going or how they're spending their life at all. So first and foremost, it is definitely completing an expenditure schedule and really getting to know the wife to find out how they have been living their life so far. Because to be earning this kind of level of money and to be spending it, you know, yes, they've got 700 grand mortgage, but you know, is that mortgage a repayment mortgage or is it interest only? You know, these people are seriously spending. Now, these particular clients, you know, we've said they've got 3 children there in private school, automatically expect the children to go to boarding school as well. You know, the place just gets worse and worse. With the clients that I can think of, I think the last clients I've worked with who absolutely meet this altogether, the wife had no expectation to go back to work because she just couldn't see how she could possibly go back to work even when the children had gone to boarding school. She wanted to maintain the same level of living, but more importantly, with this wife, when we worked with the last one like this, she had her expectation of how much maintenance she would be receiving from the ex-husband to maintain the standard of living. There was no grasp of what the husband's needs were in all of this. So actually from an advice point of view, she comes in initially to complete the Form E because she can't do it herself, because she doesn't, it just fries her brain too much to be able to do it herself. But actually what you end up doing as a financial advisor is you end up coaching this kind of client, because you need to be coaching them to start having a reality check of what life is going to look like post-divorce. So for me, then, working with you, Graham, on this kind of case and finding out what the settlement could look like is really important, because she's going to be going through so much upheaval in her life. She's going to have to come to terms that her current lifestyle is not affordable. She's probably going to have to come to terms that she cannot stay living in where they currently live, that she's going to have to probably move out of area or certainly downsize considerably. There's going to be a massive change to her lifestyle expectations. But for me, my role here is very much, when I start seeing what the potential numbers could look like, to start empowering her with what kind of property she could have and what this does mean to her in relation to how much they can spend. There is no point completing the Form E, the expenditure schedule of the Form E, and just getting on with it. I regularly sit down with clients and we get onto Zoopla or we get onto Rightmove to see the kind of property values, to see what kind of property she could buy with the potential assets that they've got. Equally then, coming back to you, Graham, and things like that with maintenance, with mortgage capacity reports. For this kind of client, it's so important to get a mortgage capacity report, because if her mortgage capacity is going to be based on the maintenance being paid, how is the maintenance going to be structured? When is the maintenance going to start? Because most mortgage lenders will not look at maintenance until it's been in place for at least 3 months after the court order's been signed. The majority of mortgage lenders, bar none, will not take into account annual maintenance being paid from bonus, or if they do, they certainly only take a proportion of it. So she really does need to have her eyes opened as to what vulnerable position she is in, especially if especially where she's potentially trying to sort things out, potentially with her husband directly and not involving solicitors too much. They could find that selling the family home far too early on during the process could really be to her big financial detriment. So she needs empowering to understand what she can and can't do, and what things she should be really aware of when she is going through the process. Then secondly, that's really her. And then for, with you, Graham, it's very much helping you understand what the key numbers are and what the key non-negotiables are in the home settlement, so that, if we know that actually the mortgage is really not looking very good at all because of the way that maintenance is going to be structured, then empowering you to understand then what kind of things that could be done instead on that.
Very helpful, Helen. I think the two key phrases I took from that were reality check and empowerment. And they both deal with cascading emotions. And I think, as everybody knows, when people are going through divorce and separation, there is that element of trauma sometimes, and it's often very difficult to get onto that conversation. But when you do get onto that conversation, it's actually about finding a way through and getting to the other side, and how somebody's going to feel in a year's time. So getting the right information, using the right tools, using that interface that Claire was talking about earlier, just seems so important. Now, I'm not going to put you completely on the spot here, Claire, and no one's going to hold you to this advice, but just be helpful to know, how would you evaluate this, and what points would you take into account if I were coming to you for advice on settlement?
This is a really tricky case, and I think both parties are going to have a real shock. As Helen said, their lovely lifestyle is about to come to an abrupt end, because what the court will be doing is to try and achieve a fair outcome for both parties on the road to independence of each other. And whereas they've lived very nicely on 400, say, net income a year in one household, they're now going to have two households using the same income. From Mr. Jones's perspective, he will be saying that £600,000 bonus, that was a one-off. I'm not going to get that again. And in fact, I'm at risk of redundancy. It's all very difficult. So, I need to be as financially secure as possible. So those are the sort of arguments he would be portraying. And there's also, it would have to be borne into consideration that bonus is not guaranteed, of course. And so from that perspective, he's probably right to raise it as a red flag issue. And the courts are sympathetic to that. And what tends to happen is that the court will look at the guaranteed income and give a share of that to the wife, and then say, well, if there is a bonus, and we think there is likely to be, you will get a share of it on a fixed or reducing percentage. And obviously, then you're going to have issues as to, well, how the child support, which the courts don't deal with, the Child Maintenance Service deals with. What is the child support going to be? What is the wife's spousal maintenance going to be? And what that also has to be juggled against is housing. That's a priority here, because obviously the court wants both parties to have a home in which to have their children with them during the times that they are with each parent. But they haven't, at the moment, the mortgage is $700,000. Obviously, Mr. Jones can currently support that sort of mortgage. Mrs. Jones wants to stay in the house. She wants to maintain that stability for the children. She isn't too concerned about what Mr. Jones does. And so her priority will be to stay in the house. He can pay the mortgage, he can rent a flat somewhere, and the court's approach will not be that. And so as lawyers, we're having to say, well, actually, I think the court, with this sort of mortgage, you're not going to be able to stay there, because in terms of the mortgage borrowing for the whole family, his 800,000, and say he'd actually had a high level of bonuses going back over previous years. Mortgage companies, as Helen's already said, are very chary about relying on bonuses. So they will look at the salary, and you may have to think about using bonus allocations to pay down or to reduce mortgage borrowing at some future point. His salary is not going to be able to support 700,000 mortgage for both houses. So the reality is that this is likely to be the case, that they're both going to have to downsize. And so the mortgage capacity report for her is, as Helen has indicated, it's going to be crucial, because we're looking at, well, at the moment, she doesn't have her own earned income. The youngest child is only 5. So in terms of her ability to borrow, you're going to need the mortgage advisor to advise as to what the companies will be taking into account. What's the term of the maintenance going to be? What is her expenditure likely to be? Does she have any debts that need to be factored in? You're going to need some really strong advice in relation to that. And obviously, as Helen said, looking at Rightmove and what are alternative property costs going to be. Obviously, the court's priority is that the children have one main home if they can't afford to buy 2. And so that will be a factor to consider as well. But in terms of how the available capital is divided up, that will dovetail into, well, how much borrowing capacity does each party have based on the mortgage reports, and how are we going to factor in bonus payments? So this is a very tricky case, actually. And I think that there's going to be a rude awakening. And the difficulty is, the husband may well say, well, give her some of the pension. I need more of the capital now. And she's going to say, I need the capital now. I'm not going to retire for years. I don't want the pension. You keep the pension. There'll be arguments about that. I think the court's likely approach is to say, well, you're both going to have to share the pension and share what's available, because the important thing is housing need in this case and how it's going to be achieved. So that is the real issue here, I think. And a reality check that unfortunately is going to come home for both parties.
Claire, if I can add in as well for the mortgage capacity report for him as well, because he's likely, as you've indicated, to have child maintenance payments and spousal maintenance payments, and also school fees. Those have a massive dent and knock on the amount that he can borrow as well, because it might be that when they originally took that mortgage out, they only had maybe one child in private school or two. And, with this particular one, they're looking then at going to boarding school, which, as we know, boarding school costs double the amount that private school costs. The costs are just going to escalate and escalate for this person. So, whether private school remains affordable for them as well is something that would be interesting then for them to explore, I assume.
Absolutely, I agree with that entirely. And I think also where you're looking at bonus, it may be that if he gets a bonus, they stay in private school. If he doesn't get a bonus, they're out. Because private schools are nice to have, they're not a need to have as far as the court's concerned. And if mortgage companies aren't going to take into account the bonus, well then that's the luxury that may be affordable from that resource. But they're both going to have to agree that that's their priority. And I have to say, I think boarding school is definitely a no-no. They're really going to have to focus on housing both of them for the future. So I'm afraid I would be saying no boarding school, private school at a push if you're using the bonus allocation to do that. And if he doesn't get a bonus,
we're going to wrap up shortly, but I was just going to say, if anybody's got any questions for Helen or Claire, please send them through on chat. But I was just going to comment in the meantime that although I've kept quiet as the solicitor, hearing the discussion in such a calm and measured way, it just reminds me of how important it is to get to this discussion. And it's so important in terms of how you think about approaching these things. If you've got a client who's getting divorced, what are they looking for? Are they looking for a focused, calm solution, or are they looking for a fight to get back at their ex? Because if you go down the latter route, you can do that. You can end up in court. You can end up sitting outside of court. You can go and see a judge who will not know very much about your case, who might give you 20 minutes of their time on one occasion, a bit more time on another occasion, and you may end up with a solution imposed on you. But if you actually want to get the right solution and a focused solution, and one, I always think the best solutions are the ones that work for the whole family, because if both spouses can live with it, and if the children can live with it, they'll thank you for it in a year's time when they come back and you meet them and say, well, how are things now? So I think it's just a question about thinking about these things. And I think because of this area, it's such an emotional thing, the whole thing, the disclosure. I mean, this particular example would trigger so many emotions just going through that, particularly if a couple has been married for a long time. It's about getting the advice at the right time, really, I feel. So I just wondered if I could just have some closing thoughts from the other speakers before I wrap up. So going firstly to you, Helen.
Yeah, I know there's actually quite a few financial advisors on the call today, and for me, what I would be saying is any work, this type of work I find personally incredibly rewarding. I find it mentally challenging, really rewarding, but the most important thing that we have to bear in mind is the clients that we're working with are incredibly vulnerable. And when people are vulnerable, they really do not hear potentially all of the advice being given. So I cannot stress enough that any work that we are doing with clients directly, when we are giving them advice or we are doing cash flow modelling for them, it is so important to involve Graham and the other family lawyers within those meetings, or certainly to have a meeting note afterwards with what the key bits that came out of those meetings, because ultimately it's Graham and Claire who are going to be the people agreeing the settlements on behalf of the clients. It's not going to be the client, and that's why empowering Graham is, for me, the most important aspect of the work that I can do, because it enables him to deliver the best outcome for the client.
Okay, thanks, Helen. I prefer empowerment to having reality check. I think I get that every day anyway with my partners. But anyway, and on to you, Claire, if you have any sort of final thoughts in summary.
Because the approach of the courts is not fixed. It's not just a case of 50-50 and that's it. It's a discretionary based outcome. Information can be used in a very flexible way and a nuanced way to achieve what may best suit your clients. And that's why I think actually having a sophisticated input from a specialist IFA can really help make arguments, because you want to try and get a settlement because that's best for everyone, frankly. And getting arguments on board that are based on a determinable set of facts that are evidenced in a report really carries a lot of weight, I think, and will help people. And actually, I think, Graham, you're a big fan of the collaborative approach, and absolutely in the collaborative approach, the use of an IFA for both parties, I think, would be really helpful to try and encourage both of them to get to a result that they can both live with.
Thank you. But also, we can also rely on your powers outside of court very often to get the settlement that we need. And in court if we have to, and on your arithmetic, which is second to none, because I've seen it. So anyway, that brings us towards the end of today's webinar. Thank you to Helen and Claire for their valuable insight and wisdom. And as you can see, these issues are best explored through a combination of family law professionals. Thank you also to our audience on Zoom today, and we hope to meet again in person next time, whenever that becomes possible. Thank you.